I'm Manny Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and today's video is another in our series entitled Real Estate Fundamentals You Should Know. Today we are talking about a topic that I consider one of the most basic listing principles that every listing broker must incorporate in their practice. If you aren't doing this already, you have to start doing this. The very first thing you do after you take a listing agreement from a seller is order the preliminary commitment for title. And there is absolutely no substitute for the preliminary commitment for title. Ordering the information packet from the title company, going online and getting publicly available information, getting the old last recorded warranty deed, none of that substitutes for getting the preliminary commitment for title. And there are a number of reasons why, and there are a number of things that you need to look for in every preliminary commitment. I can't give you an exhaustive list because it's entirely possible that on any preliminary commitment, there's going to be something important for you to know that doesn't come up in the normal transaction or that I'm not going to think about today. But I'm going to give you a list of some of the basic things that you need to look for on every single preliminary commitment for title that you pull, and you have to know this information before you market seller's property for sale. When you put the property in the MLS computer, not only is your seller advertising the property for sale, but you are advertising the payment of a selling office compensation to a buyer broker's firm if that firm, buyer broker license to that firm, brings a ready, willing, and able buyer for seller's property on seller's price and terms. And if it turns out that your seller can't clear title because of a fact that you should have discovered by a careful review of a preliminary commitment for title, then it's entirely possible that the buyer broker's firm will have a claim against your firm for the selling office compensation. Okay. You've got the preliminary commitment for title. It's critically important that you actually open the link to the preliminary commitment for title and that you review the preliminary commitment for title. Very first thing you're going to look for, and please don't think that I'm being ridiculous when I say that, when I say what I'm about to say, but the very first thing you look for is who owns the property. Who is the seller? You've got John Doe's signature on the listing agreement, but if it turns out that the property is owned by the living trust of John Doe, then you don't have a listing agreement signed by the seller, because the listing agreement would have to be signed by the trustee of the John Doe Living Trust. And it may be that John Doe is the trustee of the John Doe Living Trust, but if all he's signed is John Doe and no explanation of his title as trustee for the John Doe Living Trust, then he, through his signature, has not bound the trust, which is the owner of the property, to the listing agreement. So the very first thing you look for is who owns the property. And if the owner of the property is anybody other than the person or persons who have signed the listing agreement, then you know you need to get right back to square one immediately. Let's take the situation where the property ends up being owned by an entity rather than a human, whether it's an individual or a pair or whatever. Let's say it's owned by an entity rather than a human or a set of humans. And by that I mean a partnership, a corporation, an LLC. It could be owned by a person, but that person could have another person signing on their behalf through a guardianship or a power of attorney, for example. It could be the trust situation. It could be an estate for a now deceased seller. If the seller of the property is anybody other than a human being or set of human beings, whose name actually appears on title as the fee simple owner of title to the property, then you should go immediately to the title company and ask the title company what the signature for this seller should look like. If it is a trust, for example, or an estate, or an LLC, or a corporation, or any other entity like that, the title company is going to tell you that before it can answer that question, it has to have a document identifying who has signing authority on behalf of that entity. If it's a trust, they need a copy of the trust agreement. If it's an LLC, they need a copy of the LLC agreement. If it's a corporation, they might need the articles of incorporation, etc. Only with that document can the title company then tell you what the seller's signature should look like. The seller's signature, as described by the title company, should appear on the listing agreement. It should appear again on the face of Form 21 on the signature block for the seller. And then the escrow company will use that same signature block when creating the deed at the closing table. All right, preliminary commitment for title, first thing you're going to look for is who owns the property, and if it's anything other than a human or a set of humans, you're going to go to the title company and ask the title company to help you define what that seller's signature should look like. What else are you going to look for on the preliminary commitment for title? The legal description. Without a complete and accurate legal description, you cannot create a binding purchase and sale agreement. So if you want to empower a buyer's broker to write an offer that your seller can then actually accept and create a binding purchase and sale agreement, then you as a listing broker must attach to the listing printout a complete and accurate legal description. It is not a substitute to pull the abbreviated legal description off of the county website. You have got to get the Exhibit A to a preliminary commitment for title and attach that as a document, an attached document to your listing printout. Buyer broker can then print it out, attach to buyer's offer. Buyer can initial it and date it and send it over with their offer. If seller accepts, then we have a binding agreement, at least with respect to the legal description. What else are you going to look for on the preliminary commitment for title? All of the encumbrances recorded against title. What's the debt level set forth in the encumbrances? You're not going to get an entirely accurate picture of the encumbrance level, because if it's a deed of trust that was recorded 10 years ago, it might say that it's a deed of trust for $300,000, and some of that might be paid down. But you're going to get a pretty good picture, at least enough information to be able to clue you in to whether or not this seller is going to have trouble clearing the monetary encumbrances on title based on the sale price or the value of the property that you and seller are arriving at based on your broker's price opinion. In other words, you're not going to get an exact number for the encumbrance level, but you're going to have enough information to know whether or not seller needs to get more information from the debt holders before you get that property on the market. What else are you going to look for? You're going to look to see if the property has cc&rs recorded against title, and if it does, do those cc&rs indicate some restriction on selling? And if they do, is that a lawful restriction? For example, if there's an age restriction set forth in the cc&rs, does this property qualify for the senior housing exemption in the Fair Housing Act? This is a discussion topic. If we could pull this out and set it aside in another video, which we've already done, then that would be a beautiful discussion to have. I can't link you right to that discussion at this moment, but I will tell you that if you're not sure what the senior housing exemption of the Fair Housing Act means, or what I mean by the question of cc&r restrictions that may be lawful or unlawful, then you should watch the Fair Housing video series available through the Washington Realtors YouTube channel. So you're going to look at cc&r restrictions and determine whether or not they're lawful or unlawful as you market the property. You're also going to look to see whether or not the property is in a special tax classification. Is it held as open space or timberland? If it is, your seller is going to have to address that issue at or prior to or at the time of entering mutual acceptance with a buyer. If your seller says nothing at all in the purchase and sale agreement about the fact that the property is in special tax classification, then at closing, your seller will necessarily and unavoidably owe 7 years of back taxes. It is typically a number much larger than any seller who's caught unawares is willing to pay. Seller needs to recognize the impact of having their property in a special tax classification at the time the property is listed. What are they going to do with that information? The form you're going to refer to in helping the seller figure out what they're going to do is the Form 22L and A. 22L and A, paragraph 6, is the only provision in the entire statewide form system that allows a seller to negotiate special tax classification and allows the seller to either require a buyer to keep the property in that special tax classification if the local jurisdiction will allow them to do so, or it sets up a platform for negotiating who between the two parties, even a combination of the two parties, will pay the back taxes owing. Final thing I want to point out to you that you're going to be looking for when you review the preliminary commitment for title is whether or not this property falls under the category, a newly defined term called common interest community. That term, common interest community, is created by a brand new law that just came into effect on July 1st, 2018. We refer to the law as Wakaiowa. I'm going to tell you all about Wakaiowa, but I'm going to tell you in another video. I'm going to tell you right now, you have to have the preliminary commitment for title in your hands to be able to determine whether or not the property you're selling is subject to Wakaiowa, whether it's part of a common interest community. Do you care whether or not it's part of a common interest community? Absolutely. You have to care, or else you won't be able to do a competent job for your seller. Lots of important information here. If you have any questions about anything we've talked about in this video, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.